But briefly, I just mentioned a few things. One, in fact, if you read Kevin's minutes from the last Family Law Committee meeting, we've had some changes in the division. Both Meg Marcoulier and Dave Brodsky went on to other divisions, and they both did outstanding jobs, I think, when they were there. I mean, Meg put together, or helped put together, a really nice child's rep and GAL seminar last year, and Dave took a lot of, I'll use the term because I'm going to use it later, heater cases. Although we did let him take the gray case with him since he hasn't ruled, and they filed a motion to reopen proofs. So now he's got 15 boxes sitting up in 401 that he gets to look at every afternoon when he's got nothing else to do. We also picked up Patricia Fix, who I think is an outstanding asset to the division. She's a circuit judge, makes her on one level an asset because there's one more vote up in the room to try to get more judicial resources for the Family Law Division. Number two, she was probably one of the best trial attorneys they've had up there in a long time. She tried most of the heater cases up there, like the Marty Yang case, which was the one of Sean Gale's girlfriends being murdered. She tried that case. She was lead counsel in that. Lead counsel in most of the heavy cases they've had up there in the last few years, as they say, the heater cases. And she definitely knows what proper decorum is in a courtroom. And she also has an interest in family law and wanted to be in the division. One, she was one of the early people in developing the domestic violence unit for the state's attorney's office. I believe she was the first chief of that unit. In addition, in her own personal life, she has 3 children, and one's a special needs child, so she's been involved in special needs networks. So she has a lot of issues in her life, both professionally and personally, that wanted her to come to the Family Law Division. We have Chris Morozin. Now, as I say, who better to tell you about Chris Morozin than Judge Chris Morozin?
Yeah. Wow. Jay asked me to take about 10 minutes to give a little background on myself.
I actually said 30, by the way, starting with the hospital he was born in. But
30 seconds. I was in private practice for about 20 years with the same law firm out of Fox Lake and Waukegan, and my primary responsibilities included handling the family law cases at my law firm, which were challenging, but it provided a great background for coming to this courtroom, I think, and having this new assignment, which I look forward to. I've been on the bench for about 3 years now, and I primarily handle traffic and misdemeanor cases, but they were looking for a new judge to come to family law, and I volunteered, and I'm looking forward to this assignment. By way of my family background, I've been married for about 18 years. I have 4 kids, and I too, like Judge Fix, have a special needs child. I have an autistic son, so I'm sensitive to the needs of children and look forward to the assignment and helping people out any way I can. So.
I would say we made Chris think he volunteered to come to the division. Actually, when Judge Foreman started talking about changes potentially a year ago, Chris is actually the person I targeted, knowing his background and having known him for 20 years, both as fellow local prosecutors and people who also had to take cases in the Family Law Division for a long time. Now, very quickly, George Strickland is going to make a return visit to the next Family Division committee meeting in my courtroom on March 20th, and he's going to be talking about the new procedures and forms regarding gun seizures. Recently, the Rules and Forms Committee, which I chair, approved new forms for gun seizures. And anyway, a court can issue a seizure order after finding that the person is a credible threat. And George will go over what a credible threat is. Now, the other day on the way to work, I was listening to public radio, and it was the day after the State of the Union message, and a reporter for public radio was interviewing Ted Nugent on gun laws. and Ted, in his normal calm, zen-like, logical manner, was discussing gun laws and how we don't need any more. He said, we know who the nuts are. I don't want to hurt anyone in the 604B by using the term nut, but that was just Ted's term. And he says, we know who they are. We knew who they were in Newtown. We knew who they were in Aurora. Just take the guns from the nuts. Well, I think if his community starts taking the guns from the nuts, the first person who loses guns would be Ted Nugent. Now, real quickly, and I'm going to finish up before 12, Tom.
Okay.
In fact, if I do, will you buy dinner for me tonight? But that might be a violation of some ethics rule. But anyway, the trial calls, we're now into our third go-around of the trial calls, and they've been actually working better than even we expected them to. We've been getting through them smoothly. The cases are almost all settling, but a couple of cases get continued if they file the motion and for cause, and Tom, I recently continued one of his cases, so he can verify that. And now we were really concerned about the first 4 rotations, because those are the cases that have been hanging around for a couple years. They hadn't been settling, and they weren't put on a track. Starting, I think, April 8th trial call will be the first time that we actually have put on the simplified or expedited cases onto a track, and hopefully it continues on like that. I can actually see a problem on my trial call April 1st, but I think Michael Berger and Carl will work that out ahead of time. And another one on May 28th, which I think some other people will work out. But anyway, it's been going, as I said, really well. I think it's really helped the division a whole lot. Now, as to these forms, do we have another half an hour, Tom? But anyway, I think a lot of you got copies of these forms. A lot of the standing orders that are in here, whether it's the motion practice, final trial conference, standing rule, default motions, and trial call, are really just taking existing standing orders that are in the civil division and just putting them into the family law division with a few changes. And as Judge Johnson put in my notes here, in this version, incorporates changes requested by the Bar Association, because we did put them out and let them be vetted by the Bar Association. I will say most of the changes are actually grammatical changes recommended by Kevin Kane. And that's the problem when you give the former editor of the Kent Bar Review time to look at something. As to the couple of forms, you can discuss those with Chuck Johnson at the March 20th meeting. And we did amend a few of the rules, too. And one was 1108, because if you read 1108 in its former form, you would get confused on what a case management, subsequent case management, and trial conference were, because sometimes the words are used interchangeably. We also changed the emergency motion 1110 quite a bit. I mean, quite a bit and not at all. We took our old one paragraph, looked at, I believe it's 2.05 in the civil division emergency, and basically took that, put a couple sentences in front of it, and turned it into a new 1110. Chuck's the kind of guy who can figure this out, managed to find a typo in 1111. So we corrected the typo, had been there for 15 years. And also 1105, which deals with the 604B and the evaluators, we took quite a long time to make some changes there. We got input from the bar and input from the evaluators on making those changes. And one thing we did put in was a mentoring program, because if you look at the old rule, you had a requirement of having had 2 years experience as doing an evaluation. Well, if you didn't have 2 years experience doing an evaluation, you couldn't become an evaluator, sort of like the old catch-22 thing. So we developed a mentoring program for those people who had the background and experience to become 604Bs by having present 604Bs, mentor them through their first 1 or 2 evaluations. So I think that's it, Tom. I believe it's
You're
under by 5 minutes, so.
The default.
Okay. Well, Chris brings up, and that's covered in the standing orders, there is the new standing order regarding defaults, which requires you to come in and ask for the default and then set it for a prove-up on another court date, and making sure whether the person's filed an appearance or not, you give them notice. Those will all be posted shortly. They've been passed by the Rules Committee and signed off by Judge Foreman.
So I think that the process will be, I know it was customary when I was practicing law, you would default someone and do the prove-up in stanter right then. Now you're going to have to go through the process of filing your default motion, having someone held in default, and then send a copy of the court order out, and then come back on another court date for your prove-up hearing.
Is that required if you've got a stipulation for a default?
No.
No.
You have an agreement where you have someone participating in it, and you'll have their signatures on that, I'm sure, so.
Okay, Tom.
Great, thank you.